So thank you very much, ladies and gentlemen. Good evening, and welcome to this webinar, which I'm delighted to do with Nishith Desai Associates and the panel who have been put together this evening by NDA. I've known NDA for a number of years now and have absolutely the highest regard for them, as well as my colleagues. Can I just re-emphasize to everybody, there are two potential boxes that you can write in. There's the chat box and there's the Q&A box. I will try and pay attention to the chat box to see if anyone accidentally writes a question in there, but I can only do so many things at any one time, so if possible, please put questions in the Q&A box, because that will make it easier for me. And as Vanessa said, we will take questions either as they crop up, if I see them and they're relevant to things that we're talking about, or towards the end. This isn't no secret. This isn't the first COVID-related webinar that any of us have done, or I suspect attended. We are now about 15 months into the pandemic. I was in the UAE last year in early March for a hearing when the WHO started to announce that there was a pandemic and countries started to shut their airports and shut their borders. I had Indian colleagues who were worried about getting out of Dubai and getting home at that time. We'd already had reports from China as to infection for a couple of months by that time, but it was really March and April that things sort of took hold. At that time, I think it's fair to say, a lot of us thought that the whole pandemic would be done, dusted, and finished by September. I had people who were trying to maintain commitments in September 2020 on the basis that we would all recover from it. We're now 16 months after that. All the jurisdictions that I know of have had multiple waves of COVID. The experience that we have now in retrospect is very different to what we had or what we anticipated last January, February, March, April. So first question for the conversation, and I'm going to try to run this as a conversation rather than doing a series of talking heads. I just want to go to our various panelists and say, what's your general experience been of COVID and the pandemic on either your practice or your business dealings? I think, Rajiv, you are our industry expert, our in-house counsel. What has the effect been, in your view, on the pandemic, on the construction industry as a whole?
So thanks, David, and thanks, NDA, for organizing this very relevant topic. From my side, one announcement that whatever I express here are my personal views and not the views of my organization. So, David, on the general outlook on the construction as far as the COVID is concerned, it's a very unique situation and proposition where initially, as you rightly said, that when the COVID stuck early in the first quarter of 2020, and I say that calendar. So basically, it started somewhere in China in say around December, but in India, it actually we started thinking that is something very serious as COVID was somewhere in the month of March, and I think 24th or 25th of March is when the government of India actually announced a lockdown. So at that point of time, I think the immediate reaction of many corporates, including the company in which I'm currently working, because we are an organization which are completely sold out in terms of capacity, and hence we were planning we're already in conversation, or in fact we were in very advanced stage of finalizing the contracts, and in few cases we had in fact also signed a letter of intent, and that is what triggers the zero date as far as any project is concerned. But when the pandemic stuck, and as it happened with many corporate, it happened with us. I think the theme was to conserve as much cash you can, because the future was uncertain. The way markets plunged in the last week of March and first week of April, almost half the wealth of or market capitalization of the most of the companies was wiped out. So there was a knee-jerk reaction, because we thought whether it will be an end of the world, and that is where you basically try to conserve cash as much as possible. Uh, and we actually invoked force majeure notices to many of our contracts, and I'm sure many such corporates who were in a similar situation would have done the same in terms of enforcing. Although the word like pandemic was never there in our force majeure contract, because nobody, with the best of the capabilities, I would say, with the best of the lawyers and law firms advising us you in such large scale contracts. Although the Spanish flu was there in the early 90s, but I think most of us had forgotten that. At least I was never aware of this Spanish flu in the way now I am aware. So, and then after I think almost a month or so, the economy started to reopen. Then, when things opened, we have our projects. So, from the reaction to a post-COVID situation where things started normalizing, and in fact, in India, we actually thought, including the government of India, that COVID is gone. In fact, our Prime Minister declared that we have won the war on COVID, and that is where we recalled our force majeure notices, and then we have even finalized further contracts after that. And now there is a situation where post COVID, now many of our suppliers, if I may say so, want to invoke force majeure. So we are in a very typical situation, where you have signed a contract during pandemic, right? Fully knowing that there is a pandemic going on, and there may be, because typically in COVID, I think the way it works is there will be a lockdown, then opening, then lockdown, then opening. That is how it goes. Uh, I think we have accepted that COVID is the new normal. So, in light of this, we will have disputes. And when I say we, doesn't mean my company. Means in India, I think once the situation normalizes, I foresee a plenty of litigation on construction projects. So I will stop here. I just wanted to give you idea about what was the situation early 20 and what is the situation now, where we continue to receive force majeure notices, and I think it has to be seen whether actually there is a force majeure or not because of the COVID situation.
Reggie, thank you very much for that. We will, of course, drill into some of these issues over the next hour and a bit. Mino, your experience in Korea, is your experience the same or slightly different in Korea?
We have seen in the Korean construction industry last year and in the first half of this year, generally speaking, fewer disputes than before. And my observation of this phenomenon is the industry doesn't know which traditional type of claim this situation fits into. It's not a employer fault based situation. It's no one's fault. It's not a variation, and no one knows what to do, how to monetize the situation. As Rajiv rightly mentioned, pandemic doesn't show up in any of the contracts that have been entered into, nor does the law capture the situation and make this a money claim type of category, I'd say. So the industry is pretty quiet, I'd say, for now. The industry is waiting for precedents and benchmark examples as to how this would be resolved legally, and until then, the contractors in Korea are rather staying low-key and trying to resolve it without escalating the dispute.
David, is David Goodman, from the expert's perspective, Rajiv has identified that or the industry is trying to hold on, or has tried to hold on to cash, and is now facing the difficulty of contracts that were signed with COVID as a reality. And Mino, very interestingly, saying that in some ways people don't know what to do with this or how to monetize it, what sorts of claims to advance. And I think that reflects what I've seen as well, that when looking to advise clients in relation to some matters, there are presently no reported cases on some of the issues around COVID. What are you seeing as an expert and as a delay expert? Are you, I imagine that people have already called you in. By the time it comes to Mino and me, then everything's fallen apart. But what's your experience? What's your general experience at the moment?
Thanks, David. So I think, last March, which almost feels like a lifetime ago, when things really started to hit in London, in the UK, and in some other jurisdictions that we're looking at, the first thing that we saw contractors do was to immediately start to reprogram their works. So they sat down and said, okay, there's a pandemic. No one really knew the extent, how long it would go on for. I think the initial feeling was that by September we'd be out of it. So everyone was trying to program, well, I'm going to program for the next 6 months, and very kind of ballpark figures of, strict social distancing, strict changes to logistics, and the kind of ballpark was we're going to hit 50% productivity, and everyone quickly reprogrammed their jobs to see where that date was, where their completion date was then heading with this kind of first pass overview. Obviously, we now sit here, as you said, 15 months on. We've now got lots of historic data. And I agree, there's been a nervousness to conclude any matters because it's ongoing. We don't know where it's heading. And those first initial programming exercises can now be checked against reality. And what we've tended to see is on high-rise tower blocks where you are doing fit out works where everyone works in close proximity, that's obviously significantly been affected, because when you used to be able to flood an area with all the different trades, that's now being very controlled. But in major civils projects where social distancing is much less of an issue, it's starting to return to normal. But everyone's positioning themselves, and we're seeing lots of contractor type loss of productivity claims on our desk, and similarly contractors asking us to advise on what they think we should do. And it's still, we don't know how long it's got to run. So from my point of view, it's making everyone realise that record keeping, as we always say, record keeping is key. And hopefully over the last year to 15 months, people have been seriously keeping their records for that time when things do start to turn into formal disputes.
Thank you, David. It's interesting what you're saying. Mino and Rajiv, people cooperating, people holding on to cash. What you're saying, people making records and starting to sort of build claims to try and work out what happens once it's clearer. Ashish, sort of your general experience, but also one of the things that picks up what Rajiv sort of said earlier and what David was talking about, that we didn't know what was coming, was last year we were getting all sorts of notices and exhortations from governments and government ministers that everyone in the industry should cooperate, people should allow the sort of reprogramming that David talks about. People should be sympathetic towards claims and cash and all this kind of thing. Your general experience, but also, do you think people did cooperate last year in the way that governments asked us to, or asked the industry to?
Sure. So let me first start with what the government did in India, and then probably see if the people did that or not, or what path did they choose. So the reality is, unfortunately, the government in India, like other countries, did come out with these certain measures to help the construction sector. But the unfortunate fact was that those measures have been found to be insufficient as on date. The government, and if you see the construction sector, particularly in India, is largely driven by the infrastructure side, where all these large projects, which are all sort of being issued by the government. So there are all these contractors bidding for projects to be given by the government or various different government arms. And the government and various ministries, such as the Ministry of Renewable Energy, or it be the Road and Transport, or other ministries, which are their Ministry of Finance, also broadly wherever they are involved, they all came out with notifications. And sadly, they all said, and agreed in that sense, they all said that we'll be very happy to give you the time that you need, additional time that you need to complete your projects. But they brought it with 5 sets of riders, which said, A, we need to extend your bank guarantees. B, we will not be paying you any additional increase in your project costs. C, if you had defaulted earlier, you will not be able to take benefit of this extension. And there were similarly other riders which were also attached to this. So while the government has come and said that, yes, this is obviously a forced measure, we recognize it's a forced measure, but they have not given the contractors the monetary relief that they were looking for. And everybody has their own limitations. And in this context, I see India as a country, particularly due to COVID, there are large packages and relief packages being announced, which is creating huge burden on the exchequer in a situation where the tax revenues are falling. So the government is struggling with their own reality. The contractors are now dealing with these extension of times where they are not getting those prolongation cost claims. And this position which the government has taken is something similar is what we are seeing also in private party transactions, where two private parties, when they are interacting with, let's say, construction of a factory or any other such unit, they are also finding means to sort of say that the prolongation costs will not be paid off to the contractor. And equally, like as you said, in a general practice, like, because any practice follows what happens in the industry, right? That's what you're always advising on. So that's what we have also seen. We have a surge in advisory, and all the advice is not generally focused on whether there should be time which should be granted to complete the project, but it's focused rather on how do we recover costs, or can they recover costs for this particular additional time.
Rajiv, that rather goes to your observation about people trying to hold on to money. Is this your sort of experience, that people were cooperating early in the pandemic, but they were giving time but not money?
So I think there is definitely a problem as far as projects are concerned, and although even in a post-COVID period, while there is no lockdown as what compared to what we saw in 2020, the initial lockdown where in India especially came to a standstill. Things have opened up, but I think now, like especially where sectors where the demand is good and you want to increase your capacity, because it takes time to, for example, I want to build a cement plant. It takes almost around 4 months to put project on board, and hence we don't want to wait and we want to go ahead. Now, as far as genuine difficulties are concerned, I think everybody understands, and if there is a genuine problem with any EPC contractor or any construction company, basis facts, definitely companies should consider, is what is my view, because at the end of the day you want to you want to produce the first bag of cement from the new plant which you may be trying to construct. An idea is not to litigate, but at the same time, I think contractors should not take the whole COVID situation as an excuse to delay things. And even leaving apart the COVID situation, I think this is always a dispute between a company which awards the contract, or the government which act, and the contractor. Whenever there is an imposition of a liquidated damages or a penalty, it, as I go back to David's point, that you have to look at the correspondence, you have to look at your paper book in terms of what has been exchanged, and it is actually the communications on record which establishes that who was at fault. So, coming back to the COVID situation, I think it all depends whether the contractor is seeking an excuse or is trying to go behind the COVID, pandemic curtain, or there is a genuine difficulty. So, I think a lot of things will depend upon the facts and circumstances of the case. And while we speak, I think we have a couple of judgments. One judgment which comes to my mind is of the Delhi High Court, where I think the contractor was already under a delay, even during a pre-COVID period. And I think enough extension was granted in this case. And for the last leg of the delay, since there was still delay, I think it's the case of Vedanta, Halliburton Offshore Services versus Vedanta, where Vedanta basically encashed the bank guarantee, and the contractor. This is a oil drilling contract, and the contractor approached the High Court for seeking a stay on the bank guarantee, which Delhi High Court declined, saying that, and the justification was that, look here, I'm only left with 3.5% of the contract now, and hence there is no justification in terms of invoking the bank guarantee. And as you know, in India, I think the law is already settled as far as invocation of bank guarantee is concerned, that unless you claim fraud, it's a separate contract under which a banker is obligated to honor the obligation. So the court declined, and there was another judgment which comes to my mind of the Bombay High Court, which was, I think, where respondents, it is Standard Retail versus GS Global Corp. This was not relating to construction, but I think it related to supply of some steel products. And the whole point was that mere inconvenience or difficulty or delay in fulfilling your contractual obligation cannot be a ground for you to kind of claim a force majeure. So, David, I will stop here. I just wanted to give some of these precedents which we saw in the last 1 year, which immediately comes to my mind.
I think that's interesting, Rajiv. Thank you for that, and that's an indication of I think two things really. One, people looking for cash because the pandemic has had an effect on cash flow, and secondly, the hardening of attitudes. Mino, if I can turn to you, are you seeing? And obviously, the issue around bonds being called is always a concern to construction practitioners. I think what some of the first construction work I ever did in the early 1990s involved calling a bond. But are you seeing this hardening of attitudes as time is going on, and also people trying to get their hands on the cash by calling bonds and then saying, well, look, we'll work out where the cash goes once everything's been sorted out?
Yes, but let me bridge this topic with the cooperation aspect, which I found Rajiv's comments and observations quite interesting. Last year, and it circles back to my initial observation that industry players find it difficult to put this into a certain type of category of claim, and hence the contractor and the subcontractor sort of jointly cooperated to have a joint line against the employer side. It's not that there's one party who's at fault. It's not attributable. Now, as time goes by, we've seen things hardening, as you used the term, from both sides. One, from the employer side, calling the bond and cashing out, and two, the subcontractor or the supplier now raising more claims than before. Last year it was more sort of a more, I wouldn't say consortium type, but it was more of a joint defense, whereas now we are seeing more claims crystallizing. So yes, we are seeing more bond calls from the employer side taking place this year particularly.
And are they, do you think that those are, if you like, well justified, well reasoned bond calls that you would have anyway, because projects are getting into difficulty, or do you think that some of them are really beneficiaries who are using bonds as a way of getting cash at the moment and funding relatively short-term cash flow issues?
Many of them appear to be ungrounded. It could be because I'm often representing the contractor side, hence a red flag bias, potential bias factor there. But any delays that translate into LDs are not because of the contractor's fault, and any bond call on that basis wouldn't be justifiable. Now, as Rajiv rightly mentioned, the threshold for stopping a bond call or to injunct the bank to pay out is also quite high in a civil law jurisdiction like Korea. It's not fraud, but it's apparent abuse of right, which is equally as difficult to prove. What we did recently instead was to use provisional attachment, which is very similar to freezing bonds, freezing assets. We said, okay, we can't use preliminary injunction, that's very difficult, but as contractor, we have a claim against you, employer, and therefore we will treat your bond call as your asset, as a debt, and we will freeze that. We succeeded, and the court didn't require a fraud test to be met or an abuse of right test to be met. So in a way, it was circumventing the injunction threshold that's normally required, and still we managed to not pay out the money from the bank to the employer by using this method. So there are ways where unjustified bond calls could be practically stopped.
So you, and I say this with the interest of someone who does bond work on these kinds of calls. You managed to actually freeze the money in the bank.
Yes.
Because obviously, the worry in that sort of circumstance is that money is paid out by the bank. The bank calls the counter guarantee, and you then freeze it, but you still have to meet the counter guarantee. But you managed to actually freeze it in the bank.
Correct. The conceptually, the bond call was made, and hence the debt was crystallized, and almost simultaneously, the order against the employer was served on the bank, so that the bank was obliged to not pay, despite the bond call. Yeah,
that's very interesting. I'm not going to take this further because otherwise, two bond lawyers will start to get very excited and head off down technicalities that other people don't want. I think one of the issues, David Goodman, that I've seen in the UK has been the ambiguous position that we've faced in the UK, that in Scotland, the Scottish government closed sites, whereas in England, the government, but effectively the English government, said, well, construction sites can stay open, and aren't we doing you a wonderful favor? And I think actually from my perspective, I don't know about yours, you already mentioned the issues about reprogramming and productivity. But I think in England, one of the issues has been the ambiguous position that the government regulations left everyone in.
And I think, and again, I think from the projects we've seen, we had about 2 or 3 weeks where everything did generally shut down. and everyone has accepted that, and clients have said, look, EOT wise, that's probably, you know, acceptable that you're entitled to an EOT for that period. The period after that, you run into all sorts of issues. So things we've seen, such as in that period, lots of, you know, if there's an overseas labour force, lots of them returned overseas, and therefore difficulty getting back to the UK. And then if you're a contractor with multiple sites and you've got a reduced labour force, which sites do you then send that labour force to? So we've been tracking, you know, how long has it taken a contractor to get back to pre-COVID labour force numbers. So if they had 400 on site pre-COVID, how long has it taken them to return to that number? And then there's arguments about, well, why did it take you so long to get 400 people back on site? And then this is a point, I think, for you, for the legal experts on this call, because then we get into supply chain, and, you know, was the critical path of the project actually on site, or was it Italian marble not being supplied? You know, and Italy having different lockdown rules and different, you know, all the aspects of what was happening in Italy has a knock-on effect with supply chain in the UK. So it does become very complicated, and I think that's why, you know, what I've seen is, well, the 3 weeks is, you know, is a generally quite straightforward conclusion EOT wise. After that, it's still all up for grabs and quite complicated about, you know, why things actually happened as they did post official lockdown.
Other than observing that you clearly deal with much more luxurious sites than I do, the sort of normal gas-fired power station that seems to be the staple of my practice doesn't have much Italian marble in it, I can tell you. It's interesting. You've now touched on what was interesting was you started off earlier on with site closures and then reprogramming and then productivity issues, which are always interesting in terms of evidencing them and proving them. And then, in fact, interestingly, and whether it's Italian marble or whether it's just moving turbines or turbine blades or whatever, you've picked up supply chain issues as well. And it seems to me that we're running into all of these issues and teasing them out. It sounds as if your practice, one of the issues you're facing, David, is teasing out these different issues that are impacting projects.
Yeah, and then it, you know, contractually, which is not my speciality, but, you know, where does culpability lie on those type of issues where materials are being provided from another country with another jurisdiction and different lockdown rules?
Yes, I mean, Ashish, are you seeing this with the sort of cross-boundary, cross-border projects that NDA are involved with?
Sure. So in context of India and cross-border projects, or let's say we have been advising various foreign contractors operating in India, whether Japanese or Chinese or other contractors. And typically these contractors have come in India as part of certain arrangements, which, let's say in case of Japan, there will be overseas developmental loans being extended by the Japanese government, which is being used, which sort of brings with them Japanese contractors who are then working alongside Indian contractors to develop certain projects, let's say the bullet train project, which is there, the other projects which are coming up, harbor link projects which are there. So those type of things that we have definitely advised on. But the problems which they are seeing are some of those which are similar to what other Indian contractors are facing, along with a few additional ones. So what are those common ones to start with? The common ones I'll start with in context of India, the biggest one has been labor. Due to as and when a lockdown hit, the labor immediately migrates and goes back to its hometown. Getting that labor back on board has been the biggest concern. The requirements under law now say that every Indian labor has to go through an RT-PCR test. When you bring up new labor on site, they have to be quarantined for 15 days. Then you have to have thermal scanning on site health and safety requirements. All of this has led to massive increase in cost in context of labor. And someone estimate per labor, it's almost like $1,000 going up, and which in an Indian context per person in for a short period of time is a huge amount of cost which gets added on, especially in labor intensive way that the Indian sort of project contractors work or operate in India normally. The second part is the supply chain delays, where indeed these overseas contractors, we have seen that the ocean freight charges have significantly increased. It's very difficult nowadays to book bulk shipping, and there's very limited capacity internationally. So this is somewhere where we have seen the ocean freight charges have gone up. These foreign contractors were relying on certain equipment or bigger pieces to come from overseas, which have now increased significantly, caused delay as well as increase in cost. So this has been the second area that we have seen, and particularly as you asked earlier in context of foreign contractors. And third was something which is like a cyclical issue, which which all of you discussed earlier in context of bond calls. I'm not going into the legal nuances therein, but I'm just giving the factual circumstance that we have seen, which is that when these projects are being extended, people are asking for bank guarantees to be extended. Any extension of bank guarantee comes with an attendant increase in financing costs. And in large projects, these financing costs could be significant. In turn, there is a liquidity crisis in the market. And therefore, the companies who are already cash crunched are not able to get this additional liquidity from the market, from lenders at a cheap price. And their working capital has been, the working capital cycle has been distorted because the payments were planned as per project milestones. These milestones have been pushed. So they are not getting that cash through the project. They need to provide additional guarantees, and they don't have enough sources to raise capital from. So it's becoming a complete sort of a cyclical problem, which is feeding into it furthermore and leading to the increase. So these are some of the issues that at least we have been seeing in context of India, both for foreign contractors and for domestic contractors.
Just to add one thing, you remind me of the difficulty of liquidity in the market. To add one wrinkle or one twist to this is the wider spread and adoption of ESG policies, which makes it difficult, for instance, for financial institutions to extend bonds where that is required in the circumstances. So I am advising on a few projects where this issue came up recently, and I found that another twist or wrinkle to the whole situation.
That's an enormous wrinkle. As I was listening to Ashish speaking, I was thinking, well, this goes to balance sheet strength, really, in terms of working capital and access to liquidity. But yes, I mean, I think ESG has gone from being an issue that was well off our radar 5 years ago to now to being something that's increasingly come in. But actually, that I can see that those sorts of issues would come up around this around the problems that people are now facing. Rajiv, I'm not going to ask you about the strength of your company's balance sheet. Are you seeing these sorts of issues not just on site, but these supply chain issues as well that you have to manage from your perspective?
So on supply chain issue, I think definitely, especially if you have a portion of the contract where you have offshore, supply component in the contract, and if there are genuine difficulties which suppliers or contractors have come up with, and on case-to-case basis, I think I think most of the the companies who are awarding the contracts have considered and should consider, is my view, because as I told, the whole idea is to ensure that the project or the contract is executed in the earliest possible manner, and the idea is not to litigate. But at the same time, we had one contract in the state of Jharkhand, which was where we had a Chinese supplier for certain parts of the cement plant, and they were able to achieve the timelines. I'm just to give an example, but then there are supply chain issue. There is no denial of that fact, and as I think Ashish raised the point that there is an issue in terms of ocean freight and but some of these issues, when you sign a contract, I think you cannot think of a situation where everything goes as per your plans. There can be, unforeseen circumstances. And assuming if I sign a fixed price contract and the metal prices have gone down, nobody is going to pass on the benefits. So when you take a contract, you foresee both the circumstances and situation. But having said that, I think genuine difficulties, I think it's in the interest of both the parties to consider and should not go to a court of law or to an arbitral tribunal to decide the same. So that is my take. I think it should be a win-win situation as far as both the parties are reasonable. Is that what I would like to share?
I had a question in from Mutharaja. And I think it takes me on to something that had struck me. He's asked the question, please could you clarify whether additional costs due to the 14-day quarantine period implemented by governments would be compensated under change of law provision, though the pandemic is notified under force majeure. And that really goes to a thought that I had, which is we tend to discuss what's going on as being a question of force majeure. But force majeure is quite specific in terms of preventing performance of the contract. It depends how it's worded. There are all sorts of issues. You've discussed, Ashish, the internal restrictions, the internal migration of labor in India, and the fact that once people migrate, they're sort of stuck in their home state. And also the difficulties, which is what Mutharaja adverts to, of international travel and quarantines. Leaving aside that specific question, are we wrong just to say that these are properly put as claims under force majeure? Are people beginning to think of them as change of law claims or other claims? Sometimes just an instruction or a variation when employers say you will comply with this. What do you think of that?
So it's really interesting actually, and some of these questions which we see from Indian players coming in is also because of the nature of Indian contracts. For example, if you take standard contracts issued by the National Highway Authority of India or certain other government ministries, you would see that the force majeure clause itself divides into political events, indirect political events, non-political events. And it then captures change of law within political events, save and except it's not captured otherwise in another change of law provisions, which sometimes people think of that change of law is also within the scope of force majeure. And then they adopt terminologies which is different. But at the end, what we do see as a common link is that whether it be FIDIC form or whether it be standard form measures in India, they all say that in change of law, you can get your costs.
Yes.
And unlike force majeure. And that is the biggest incentive for contractors to move towards change in law. And whereas for everyone to come in and over here and assert that, look, this should be a force majeure. But what we need to see and understand, at least in context of India, which I can speak to, is that what are those provisions that you are relying on and how are you relying on? If let's say you say that there's an additional cost due to requirements of additional on-site activities such as a thermal scanning, as I was saying, RT-PCR tests, then yes, these are requirements in law which are there, which require you to perform certain acts on site, and then you may still try and move towards the change in law provision.
Yeah.
But equally, under the Indian law, the government notifications which came out, the government immediately on day one said that the construction activities can still continue and the quarantine will not prevent construction from ongoing, save and except where the construction is taking place in the cities, where if so, you can continue, but only with the labor on site, unlike in rural places where the labor could move. So if simply on quarantine, if you rely and then say that, look, because of quarantine, my project is stalled, then it may not work. Because if you see the notifications in India, it will immediately come out that the law is not preventing you from continuing.
Yeah. Yes.
And then you'll have to go to the force majeure provisions and then start looking at it from that perspective. But this is some of those things that we have seen and we have to interpret, as you rightly said early on. It depends exactly on the language of the contract, how it's worded, how it is impacting your project in a unique way, and you can find way and means. And very quickly, the last point, and probably Amino others will discuss this in more, is that very interestingly, during our previous month in preparation of this webinar, our discussions, we had discussed about the possibility of variation being used. And incidentally, last week itself, we received a query on how to use variation as a means to claim this. And we noticed that in FIDIC form, the language used is that in case you foresee future events which is going to lead to increase in costs, you can request for a variation. Now, I see because variation is typically, when it comes from the contractor side, these are value engineering efforts which improve the overall, let's say, the end product which you will get, or the timeline within which you'll get those end products. So it's not coming from the same perspective, but as people are now even thinking about, as I see, that variation, and they're trying to explore other means. And all of these efforts, as I said earlier, are concentrated towards that one point. It's not about the time, it's only about who can claim the costs.
David, I'm conscious that your focus is on time rather than money, but obviously you have colleagues who focus on money. Are you beginning to see this push towards forms of claim where people can recover money as well as time?
Yeah, absolutely. It's I think the overarching point is that it's still unknown and untested. One thing that we were discussing as well in our kind of pre-call was it's that difference between everyone cooperating and not cooperating. And I think early on everyone cooperated, and now we're definitely seeing, we're seeing the parties moving apart on both time and cost, and it's coming back down to, from my simplistic point of view, recording and documenting what actually happened, and therefore what the entitlement is. And within the industry, we've almost got back to that point where a claim lands on the table and no one believes the time and no one believes the money, and and then you have to work your way through it and actually work out what's happening. And the point that we were also discussing, do we see that contractors are trying to use it as a catch-all to maybe, the project was already in financial difficulties pre-COVID, and it's now being used as a lever to recover money that was already lost. And it's that whole element of the industry of, mutual trust is how strong is that really? And we're just seeing all avenues being approached, and just the parties taking positions on them.
I think there are two sides to the, we're in a pandemic, so we'll get an extension of time from my perspective. One is, as you say, the view of the contractor who is already in delay, or the subcontractor who's already in delay, who tries to smuggle their claim for an extension of time past the engineer or the employer under the guise of COVID. And I think the other one, which is the one that worries me and started to worry me last year, was contractors or subcontractors who saw that COVID was happening and we were in a pandemic, and suddenly just thought, well, we don't need to pay attention to anything anymore. We just do anything, and frankly, everything will wash out at the end of the pandemic, and sort of stopped paying attention, if you like, took their eye off the ball, to use a footballing analogy.
Yeah, I think there's also two sides to that. There's the party that chose that course of action and hopes that everything kind of washes through at the end, and then there's the other, probably more proactive side that my whole kind of career as an expert around the world has been about record keeping, and who's got the best records is normally in a much stronger position, and I've seen the contracting industry take record keeping to a much more to a level that has never been kept before, because they know that at some point all these records are going to have to be put on the table, and especially in a in a COVID type loss of productivity, which is always the hardest element of a claim to demonstrate. And they're taking that seriously. And from a positive point of view that I have seen coming out of this is that, people are really taking their programming much more seriously, because we've got these constraints and we've got these things that we really, really have to consider. And I'm pleased to see that people are considering them, and they're really thinking about resource movements, logistics, everything that used to be kind of a tick box, obviously not on all projects, but a tick box exercise is now being, is really being thought through, that we're building things in a different environment, and we really have to take that seriously. And I think there are some positivities that have come out of it.
Rajiv, are you sort of taking positive steps to document things differently, or things really sort of operating at a site level rather than a corporate level?
No, so I think we have a very good understanding with our project team, especially like wherever there is a red flag, wherever there is a concern, please bounce it off to us, because there is a different perspective which lawyers look at things. So the idea is to document everything, and that is how we are doing. And I think because assuming that we land up in a dispute, all these things, as David was saying, matters a lot, so I think any claim or counterclaim actually depends upon the evidence which you put forth across. So definitely documentation is very key in long-term projects or projects of high value. So that's what I have to say, David.
Mino, are you seeing notices being given of delay, or are you being asked to advise on notices of delay, or are people simply putting their cases together and leaving them? Because again, one of the other problems that I've seen is people just saying, well, why do we need to give a notice? Everyone knows there's a pandemic.
I think it's two layers. One is the way how contractors react and respond on the site level. Let me put it this way. And then there's the disputes lawyer level, which is my office. So in that regard, I think many notices are being sent out and prepared, but they wouldn't necessarily land on my desk now. So
yeah, your concern is the same as mine.
David, if I may just add on, if I am a contractor, I will first speak to my principal that, look here, this is my problem, try and sort it out before sending a formal, So in that bargain, you may get some relief. If you send first the notices, then maybe the reaction would be a little different. So
I think that actually reflects contracting reality. I think I have to say my concern and Mino's concern is always just like Sherlock Holmes talked about the dog that didn't bark. Mino's concern and my concern and Ashish's concern is always the notice that wasn't served. and having that as a pleading. Ashish, we're getting a few questions around a similar sort of theme of from an Indian perspective. Is the Indian government trying to give any support to concerned parties post-COVID on issues faced on account of labour shortage? That's from Tarun Kohli. And then there's another question. What are the policy measures that central and state governments can take in India to provide relief to construction companies? A few sort of questions there around India-specific policy. And India-specific policy, one of the issues obviously was we moved this to take account of the difficulties that India faced 2 months ago. What are the India-related policy issues that either are being implemented or could helpfully be implemented?
So I think the few steps that the government has already, and I see most of these are on the money side, like claims for whatever losses or additional costs the contractors are being incurring. So one of the few steps that the government has already taken is to say that your bank guarantees or performance guarantees which have been provided can be released proportionate to the amount of the project which has been completed instead of waiting till the end. So at least if, let's say, you had provided a bank guarantee of $10 million, $20 million or whatever, your financing charges will reduce because you can get rid of 50% of 70% of whichever amount of project you have completed. The second thing they did was they in certain cases, some ministries came out to say that we don't need to await completion of project milestones to make payments. Let's see the position actually on ground, and let's start paying proportionate to what's actually been completed on a month-to-month basis and pay. Third was that in case subcontractor payments are coming up, which can be clearly seen, and the subcontractor has supplied the relevant or delivered the relevant material or product or the service which was required of him, then to make those payments, the government will come forth and make those payments in advance in respect of whatever has been agreed with them. So these are the few measures which the government has taken. But all of these measures, if you see, are nothing but in a way to say that the costs which were initially there will be the same which we are paying up. We are just deferring the timelines on those, moving it front, moving it back, but those are the reliefs we are trying. There is not a single additional penny burden which has been taken by the government on the projects, and all of it has been shifted onto the contractors. Now, if you see the history in last, let's say from 2015 to 2020, last 5 years or so, the market was so competitive that you would see that in most projects, the companies were bidding at discount, that is below the base price, to get those projects, which had created a massive financial stress anyways on these projects. And government obviously got those benefits of people bidding below the base price as well. But now when these people are facing these difficulties, the only aspect which has come in is that the Reserve Bank of India has said that there is a moratorium and there is COVID loans which the companies could avail of. But at some level, there's certain respite, at least in terms of their not just project timelines, but actual financial difficulties, support, as we have seen in other countries where government have proactively come and supported business, at least to the extent of payment of labor costs and employee salaries and so forth, like we have seen in Singapore. Something on those lines should also be done in the Indian context, so that people can actually do it, or providing, reducing for, let's say, future projects, reducing the requirement of the guarantees for the upcoming projects. So these builders can build up their future book, basis which they can finance existing projects. So if not the existing projects, then within the future projects, they should build in certain relaxations so that book or the balance sheet can still improve. So these are some of these areas we can look at. Obviously, then it would be a whole discussion if we start exploring each one of those.
David, if I may just add one. So there was one office memorandum which was issued by the Ministry of Finance, Government of India, on 19th February 2020. And in their manual for procurement of goods, which is a 2017 manual, there was a para 9.7.7 where the word pandemic was not included. So they came out specifically saying that COVID-19 would be treated as a force majeure event, being a natural calamity. So this was limited to government procurement contracts. So, but they did come out in February 2020. But that cannot be imported into other contracts. This was specifically as far as government contracts, procurement contracts are concerned. Just wanted to add.
So what you and Ashish are both describing is government behavior as a counterpart. So when government is the owner or employer, government has taken certain steps, mainly to help either contract interpretation, as you said, Rajiv, or to help cash flow, as Ashish identified. But in terms of wider policy issues, government hasn't taken wider steps
I completely agree. The way it has been done in Singapore, I think there was a special legislation which was brought in to address contract obligation during the COVID period. I think in India, when you speak of government, government is a very wide term. It includes the government, it includes the state government, it includes instrumentalities of the government. It can be a municipal corporation, it can be like the greater Mumbai Municipal Corporation can be, as a municipality, they can issue contracts. Then you have many PSUs, public sector undertakings. Then you have National Highway Authority, which is one of the biggest organization which grants, billions of contract or what billions of dollars, especially on highways. So I don't think there has been any policy decision, especially for government contracts, which I feel was required, and that would, to a great extent, because in India is all a very litigant country. Our courts are flooded with cases. We don't see disposal. That's a different issue. I think a good government should have brought in some guideline. I understand it's not so easy, but maybe at least for the period where there was genuine, lockdown, especially 2020 when there was a complete lockdown. So I think everything is now left to individual contracts to be seen how it has impacted.
In a different context, and I'm conscious that I'm speaking as an outsider who simply has interests in India and friends in India. But in a different context, somebody said, look, you can't actually compare Singapore and India. Singapore is about the same size and population as probably West Delhi, not even the whole of Delhi, just West Delhi. Oh, well, so it's easy,
David, on a lighter note, the vaccination which was done in India, around 7 million, that's the total vaccination requirement of Singapore. So you can imagine the size of the the country.
Yeah. Yes. Well, I'm presently speaking from Western Australia, and frankly, if we had the physical vaccination numbers that India has achieved, Australia would now be vaccinated completely. So yes, one of the things that obviously we've talked about the problems that arise and the obvious problems arise. What I find fascinating about what's happened during the pandemic has been the way in which problems have arisen, and I find it interesting to talk about. Is closing sites is easy, sort of demobilizing from site and having to reconfigure sites and all that kind of thing. But I came across recently the problem where testing and commissioning couldn't take place for a project, because testing and commissioning was a project which would need performance testing for about a week, not more than that. But the testing and commissioning engineers for this particular plant were specialist individuals, and they couldn't get out of the country that they had been in the project before. And when they got into the country where the project was, they were going to have to quarantine for 14 days. That is the most sort of obscure, to my mind, example of problems created by COVID. When you tease it through, it's a problem. We only need them for about a week. I'm just wondering if any of you have other sort of strange ways in which COVID or the pandemic can affect contracts that you wouldn't necessarily have thought about before it happened.
What I was going to just say, one of the contracts I've been looking at, we've had in the UK up to very recently, you weren't allowed to stay overnight anywhere. So you couldn't stay at friends, you couldn't stay in hotels or anything. And there's sites that you cannot physically travel to every day because it's a 3.5-4 hour drive. And so the labour force, the engineers could not physically be on site because there was nowhere where they could stay. And all those things that we'd never considered before. Now so many issues get thrown into the mix that, as you said, David, just 2 years ago, it would never have, occurred to us. And now everyone's trying to deal with them.
Yeah, particularly somewhere as small as the UK, quite frankly. You don't, there are jurisdictions. Western Australia, you can actually quite see the possibility that if you can't get to a particular mine site, then you'd have problems doing it overnight. But the UK, everywhere is so close to everywhere else, you would normally think. Yeah,
but certain contractors have a policy where you shouldn't be travelling for more than 2 hours a day because it's just not healthy to have a 2-hour drive work and then a 2-hour drive home. So there are remote places in the UK that, or even if you're trying to get around the M25, I can imagine that it just extends your day. And the policy was, well, we can't actually send people to those sites because it would take them too long to get there and back again.
Yes. Turning and looking forwards, Ashish, you were talking about looking forwards in the way that actually some changes might help things. Is the pandemic beginning to flow into the sort of contract terms or contract pricing for contracts that are now being entered into during the pandemic or having seen the pandemic? Are we seeing different terms coming along for Mino and me to litigate in a couple of years' time?
Definitely, and I can say this with certainty because I was negotiating certain provisions, not to say that they would lead to disputes or they are unclear, but while we were trying to arrive at a provision, the number of considerations and uncertainties which were at play made it extremely difficult to, at that point, reconcile all interests in the best possible manner. Somewhere, some compromises had to be made. And the reason for that is this, that for force majeure, for somebody to claim force majeure, the circumstances based on which a force majeure is claimed should not be existence or known at the time when the parties were entering into the contract. Now, COVID is a known reality today. And when you're entering into a contract today, if you start claiming force majeure on the basis of COVID, this obvious objection is going to come up. Now, if you go out in this approach, it will always be a problem. So we sort of broke it down and moved further. And we said, all right, and as you said right now, what can be priced into the contract? So things like labor, the requirement of labor having to undergo COVID tests, the requirements of maintaining certain things on site. These are facts which you know now. The government notifications exist. So it's not that you can now change in law for new contracts for these things going forward. These laws exist. You know the requirements. You know the cost of it. This comes into the price. But what would happen? Will there be a third or fourth or fifth lockdown, whichever you want to call it in context of India? What will happen to supply chain again? The ocean freight charges will go down, will remain like this, or will increase, decrease? The interstate movement of goods in India, which is becoming challenging. The manufacturers who are supplying, will all the manufacturing activity come back to normal so the supplies resume and the costs come down or not? These things are still uncertain. So you have to, while negotiating the agreement, build into certain aspects into the contract. These uncertainties you have to recognize and make sure that your force majeure clause allows you to say that, look, these things still remain uncertain, and therefore you will not say that you knew COVID today as on date of contracting, but these uncertainties, we will take it as it comes along the general principles which we have used previously. And again, what those general principles should be is a matter of your independent, like your relative bargaining positions while you're entering into the contract. But basically, that's how we are seeing these issues emanate and sort of being analyzed.
And I was just going to add. Sorry, I was just going to add. And from a programming point of view, should we be programming works that now include for restrictions, changes in logistics, productivity levels, beforehand, concrete was laid at a certain rate or men on site achieved a certain level of productivity. that productivity is much less now due to all the restrictions. Going forward, is that what should be programmed into a job? And then a job that would have taken 2 years to construct, should we be saying that it's going to take 3 years to construct because of all the things that we now know? And then will the contractor actually win the work? And we were talking earlier, there's a whole nother seminar about underbidding. Part of that is, programming wise. If there's something that's going to take me 3 years, should I put a program down that shows I can do it in 2 years? So there's all those elements that now need to be considered in the current environment.
A question I had to Ashish in connection to negotiating the scope and definition of force majeure. Now, you would have to make it very express because it's not an unforeseeable event anymore. Have you experienced any resistance or adverse reactions from the insurance industry or the lenders as to your attempt to widen the definition of force majeure now, including pandemic and the like?
So I would, as I said, all of this is fairly recent, so I wouldn't say I've had that experience, but I'm just thinking aloud, what could possibly that reaction be of insurers and lenders? Lenders would obviously they would want certainty of cost and what they are lending, and eventually this is going to come out of it. But lenders typically who are lending to contractors would also want the projects completed, so they are generally flexible and around to see whatever versions will make the project complete, because that's where they will get their monies out or get their repayment. In terms of insurers, I'll have to think about it a bit more, but as I said, I'll be honest here, I haven't really seen that issue play out.
I think one of the interesting points, sort of taking the definition of force majeure, of course, there's nothing to stop further COVID or further lockdowns or the likes being an event which just expressly entitles the contractor to an extension of time or the likes, dealt with expressly in the way that we deal with other known unknowns like ground conditions and that kind of thing. The other thing that occurs to me, actually, listening to David as well as to you, Ashish, is of course change of law and variations. We normally think of them as adding time and adding money, but I suppose conceivably we could see a circumstance where we have a whole load of contracts which are written against the background of COVID and programmed against the background of COVID. And then with issues, I'm sure they'll be disputed because acceleration is always a contentious area. But I could see acceleration claims being made by employers saying, well, that's fine. We let you program this for 3 years on the basis of certain restrictions on site labor and supply and all of these things. Now, in fact, all of these restrictions have gone because of change of law, or they've simply gone, and so here's an instruction to reman the site. But as a result, we want you to accelerate and reduce your costs because you're not incurring costs. I mean, for example, Ashish, I have to say your example of the temperature probe and on-site PCR tests. You can quite easily see that those could be priced, and you could then have a variation coming from the engineer saying, well, you're no longer required to do temperature tests on a daily basis. You're no longer required to do PCR tests. Please omit these and tell us how much money we're saving.
That's sorry to overspeak, David, but yeah. So in the UK, allegedly, 19th of July, all restrictions end. So, do we have a program that runs up to the 19th of July, a kind of line in the sand, and then everyone goes hell for leather, and all restrictions are off? I think that's a really interesting point.
Yeah, and you can quite easily see not just everyone goes hell for leather, but actually owners are turning around and saying, well, don't see what the problem is. You can just get on with everything. One of the issues that I've got at the moment in the UK is a project where adjustments were made over a few-week period last April to the workforce, and the workforce went, as David said, from about 400 on that site down to about 140, 130, 140. But the other problem is we could reman that site, or we could increase the manpower on that site. One of the other problems we've got is we actually reconfigured the site because it needs gantries and walkways and all those kinds of things. And so to completely recover, we would have to close the site again for another 2 weeks and actually change the physical layout of the site for what will be the last 9 months to a year of that particular project. So that wouldn't be at all easy. Just picking up, I think in the last 10 minutes or so, got a few questions, but we've now had 3 waves of COVID, maybe 4, depending on where you are, and the number of waves has been referred to. Are they actually now beginning to have differing effects? Are we actually now beginning to have different effects for the different waves, or really when they come along again, is it here it goes again?
I think that contractors are very adaptable and have adapted to the impact of COVID, and whether there's a 3rd wave or a 4th wave, we're kind of in the zone now from a construction point of view. And I was saying before, people have really fine-tuned how their sites operate, and maybe they feel that they're before it was a total unknown, and now we know exactly how we deal with such an event, and can be much more positive about it, and therefore we're ready to go. I think it will, the effect will reduce as time goes on.
Rajiv, you're the contractor. Are you now getting better at dealing with different waves as they come along?
Yeah, in my view, COVID is now the new normal. We have to accept it, and now there is enough of vaccination which is available. So if I'm a contractor, I will get my people vaccinated on priority, and especially in the Indian context now, since the government has announced that they will get vaccination without any cost. It's like free for everybody. So, as a contractor, I am also obligated to take steps to ensure that there is no delay, and the overall objective of the contract is achieved. So, in my view, COVID is now the new normal. I think we have to accept whether it is 3rd wave, 4th wave. I think this will be a way of life, I think, going forward.
If COVID is the new normal, is COVID going to define the construction disputes practices that you and I have for the next few years?
I still would say we are craving for precedents in how different courts are dealing with this, in the absence of which I think it will be difficult to say there's a settled practice of how disputes in relation to COVID will be resolved. One interesting observation is that litigations or disputes that are not related to the construction industry may provide some hints. I've been involved in a real estate sort of M&A type of transaction in which contract terms such as material adverse effect or ordinary course covenants were being laid out and interpreted and applied by the court. And those precedents may or may not affect the law that we apply in construction disputes as well. So I'd say we have to wait and see a bit. There might be something coming along that's a bit more specific and precise in terms of guidance, but I have to see.
And finally, Ashish, you are our well, you have a mixed construction practice doing disputes and front end work, and you're our host. So your last view on your, to sum up for us, your view on COVID and where it's brought us and where we're going with it in the next year or so.
Sure. So I'm internal optimist, so I will say here that I think with any other things would be back to normal, or if not normal, if this is the new reality, even then we will see an uptick in the construction businesses, and the claims due to COVID, or as we call it, will no longer be claims due to COVID, but will go back to what we used to call it earlier, normal claims arising in course of construction projects. So we will no longer be calling them claims due to COVID. These will be normal claims if that so happens. So that's how I view it. So in any event, things will get normal and be back. And there is also, if you look at the data, you would also see that at least in the listed entities which are there, their sort of profit margins are returning. They are going back to pre-COVID levels. Before this last lockdown in India, between the two main sort of lockdowns which have taken place, there was a period where the construction activity had returned to, let's say, 70 to 80% efficiency and back to of what it was originally before the pandemic. So again, as we move forward, we will see that construction activity comes back, if not already there, at those levels which were there at the pre-pandemic level. And given that these are these closing comments, I should also do one more thing, is firstly thank Mr. David Goodman. He helped me put together today's session, get me this great panel here, and BlackRock, who helped sort of put this all together. So a big shout out to him and to BlackRock for helping us put together today's webinar. And also a big thank you to all of you. And David, it's been honors to have such a senior person actually moderate for us and then help us, guide us in our discussion today. So it's an honor for be here as part of this panel. Mino, great to sort of meet you again. And Rajiv, so your views are always welcome, and it's always a delight listening to you. So thank you all.
Ashish, thank you very much for that. I think I have nothing to add. I'm sorry if we haven't been able to get to everything that people wanted us to get to, or all the questions, but I think that is probably us. Unless anyone has any very short final words, that'll be, or has a burning question, that will be us, and we'll call it a day with our thanks to Nishith Desai Associates for organizing what has really been a tremendous panel to be on.
Thank you very much.
Thank you from me as well.
Thank you everyone, and thanks especially to Mr. David Goodman and our panelist chief, Mr. David, and everyone. It was a very enlightening discussion, and I think it's a very relevant topic. And in my view, the entire issue will evolve as things get normalized. I think many of these will end up in dispute despite all our efforts. So I think you will have all a good time.
Well, thank you, Rajiv. And it is always important to have the view of industry on this. And to those of our audience who are still listening, thank you. It would be, if it wasn't for you, we would simply have been talking to ourselves this evening, and that wouldn't have been as productive. Thank you very much, everyone.